previous provision of law. It rested where it did at the point of being repealed or being declared unconstitutional. However, the Constitution provides a mechanism by which we can determine the validity or invalidity of an election beyond Section 83. That safety net is to be found in Articles 81, as read together with Article 86, and specifically for purposes of a presidential election, we must read it together with Article 138(3)(c), which then provides the qualitative test, the process that we then use to arrive at that result to be declared under Article 138(10). So that at Articles 138(3)(c), there is a process of verification and tallying of those results that then come from the polling station and from the constituency tallying centers. All right? Under Article 81, we are then to observe certain principles of the electoral system, failing which then an election can be rendered invalid. Article 86 addresses itself to the voting method and sets out principles that then must be observed in operationalizing that voting method. That is a qualitative test. The quantitative test then is found again under Article 81, or rather 86, 2, where counting is involved of votes cast, and Article 138(4), which then sets the criteria for declaration under Article 138(10). So then it is my humble submission, even as the state of the law remains in flux, there is a standard by which we can determine the validity or invalidity of an election, and that is my humble submission on that point. The second question, Madam Chief Justice and honorable members of the Supreme Court, directed at the first and second respondent by His Honorable Justice Lenaola, was why didn't the chairperson wait until the next day and try to reach consensus and address the 27 constituencies? It is important to point out at this juncture that the 27 constituencies had been tallied and had undergone the verification process, and were ready for announcement by Professor Gullier. My lords and my ladies, I refer the Honorable Court to paragraph 35 of the affidavit of Professor Gullier, filed in the main petition. And as to the circumstances why the chairperson opted to declare the results on the very day that he did, the explanation is to be found in paragraphs 86 and 111 of his affidavit. But if I may summarize, he made considerations concerning security of his staff, who at that particular point in time were suffering arrests, abductions,